Off to you two.
Okay. All right. Well, welcome everybody, and thank you for joining us for our presentation today, Intellectual Freedom Essentials for Youth Librarians. We're really happy to be presenting this for you. My name is Kerrie Lattari, as Christy said. I am the Library Media Specialist at York Middle School in York, Maine. I work with 5th through 8th graders. I am the Secretary of the Maine Association of School Libraries, and I also serve on the Intellectual Freedom Committee.
And I am Cathleen Miller. I'm the Education and Outreach Archivist for Special Collections at the University of New England, and I serve as the chair of the Intellectual Freedom Committee for the Maine Library Association. I'm also on the steering committee for the New England Intellectual Freedom Helpline, and we'll talk a little bit about that at the very end. Thank you all for being with us. Sorry, I'm slow at advancing the slides here. So one thing that we will emphasize throughout this presentation is that we are not lawyers. We are here to present some case law that will help us to understand the moment we're in and where we stand in terms of legal protections for our work. But we are not here to give legal advice. And we will say that numerous times because it's important. Hopefully you have access to legal counsel in your libraries and organizations, but if not, we can certainly help connect you with people who can help you find that if you need support. So since you're here, you're probably aware of some of the challenges facing youth librarians over the past years. We hope to give you some information to support your work and to help you navigate the time that we're living in, which is seemingly constantly changing. I will try not to ever use the word unprecedented in this presentation. Um, so you probably also are aware that since 2020, we've seen an incredibly steep rise in censorship with exponential rise in attempts to challenge or ban books from school and public libraries. In addition, we're seeing challenges to programs, policies, and curriculum. The trends are very concerning, the current trends. PEN America's report, which we pulled this number from, on the normalization of book banning offers a really clear picture of what is happening in schools. It doesn't really address public libraries, but you can infer from there things that are happening across the country in public libraries. It is a similar picture, although schools have definitely been on the forefront of the challenges. Looking at this number alone of individual titles banned from public schools is pretty alarming, and we are all under pressure at this moment. So, just acknowledging that because it's a rough time out there, and we know that you all are doing really hard work every day. So thank you for that. ALA has been tracking censorship attempts for many, many decades now, and they offer these breakdowns yearly of data about what censorship looks like in the past year. So this is the data, one view of the data from 2024. You can see that public libraries and school libraries, as we said, are really at the forefront of these attacks on the freedom to read. You can also see that while book censorship is the major driver of these numbers, there are attacks on other forms of intellectual freedom, displays, programs, and then also looking at hate crimes happening, and vandalism of materials, vandalism of places, and also there's a lot of doxing happening out there to a lot of people. So that's another thing that we don't really delve into in this data, but anecdotally we see it happening to people we know. And often, a lot of these trends are driven by outside groups. In the past, and this is one of the big changes in the past, it was often parents or people within the community that were challenging books, and now it is more of an organized pressure campaign. And we're seeing that now across the board, and especially from the top of our government down, come directives coming at us. Um, with all of this pressure comes the real threat of soft censorship, where we are asking ourselves whether to put a book on display or to host a program. We are aware of some instances of soft censorship, but much of it happens without any conversation or input from others. We simply make choices to stay silent or play things safe. This is happening to all of us, um, regardless of where we work. It's happening in academic institutions too, so public libraries and school libraries are certainly feeling a very strict scrutiny right now, but it's happening in my world as well. So these are some questions to just help us think through our practices, the choices that we're making, because if we can more explicitly think about what our policies are and what protections are in place for us, we can begin to kind of consider how we might push against those internal feelings of needing to censor our own beliefs and ideas. So these are just some questions to ask. I'm not going to ask you to answer these questions right now, but you'll have these slides, and I would encourage you to think about these, and look around and see what's happening in your communities, in your school, in your libraries, um, and on your school boards. Even, are these things happening? Because I think it takes all of us to kind of push against these pressures. Um, so soft censorship is definitely a prominent trend in 2025, but we're seeing a lot of other concerning developments. What restricting the acquisition of material or keeping material that is deemed sexually explicit, and that definition is really murky and not well defined by anyone. And so using those words as a trigger, people are doing a lot of challenges that are um, not really based in obscenity law. So that's one of the big things we're seeing. Also, rating systems and labeling systems. This has been a trend across the United States in lots of libraries, and we'll point to some places where that's bearing out in the case law. And then obviously the limiting of DEI, critical race theory, LGBTQIA plus materials. Those are national trends that we're all really struggling to navigate. Parents' bills of rights. So like it's coming at us from all different directions, legal directions, legislative directions, and then community community directions. And the loss of funding is a real challenge that many libraries are navigating. And I will pass it to Kerrie.
All right. So, like Kathleen said, we're seeing a lot on the legislative front, and it can be really hard to keep track of it all. So, you may be familiar with ALA. They have an adverse library legislation tracker. I will toss these links into the chat after, where you can keep track of what ALA is tracking. But also the organization Every Library, they are tracking both legislation of concern and pro-library legislation, which I think is nice because if you actually go and look, there's a lot of legislation that's out there across the country where people are trying to defend intellectual freedom and defend the work that we do, which is nice to see when mostly what we hear about is the scary stuff. Next slide. All right, so the First Amendment. So we're going to be digging into the First Amendment because it's the foundation of intellectual freedom, really. And we're going to be looking at some different case law that helps us defend it. So, of course, the First Amendment includes freedom of speech. This applies to the states through the 14th Amendment. Of course, it applies to minors as well as adults. Not only does it protect our right to speak, but also to receive information, which is an important piece and something else that we're going to go over. This applies to government entities, not private, and all speech has First Amendment protection except if it's designated in one of the unprotected categories of speech by the United States Supreme Court, which we'll be looking at next. So these are the categories that are considered unprotected speech. We're really only going to be looking at the first couple as it applies to our work. So minors and the First Amendment. So you were probably all familiar with the Tinker case that involved a brother and sister wearing armbands in protest of the war. And the court decided that minors do not shed their constitutional rights of free speech at the school gates. PICO is also one that you've probably heard of. This one is really important because this is where it was decided that students have the right to receive information in their school library. So it's not just about their own expression, but their right to take in information. And then the last one is in regards to the reach of school. This has to do with a more recent case in 2021 with a student who was kicked off of her cheerleading squad because she was saying negative things about her school on social media, and it turned into this case. And they sided with her that she has her First Amendment rights in place, and she should not have been removed from her activity. All right, so with obscenity, this is with the Miller versus California case. This is where we get the Miller test, and this has been good, solid standard since it came into play in 1973. So in order for a material to be considered obscene, it has to meet all three parts of this legal test. So even if it, for some reason, we're able to meet one prong, if the other two aren't there, then it is not considered obscene. So those three pieces are that the work, if it depicts or describes in a patently offensive way, sexual conduct that is defined by state law to be obscene, whether an average person applying contemporary community standards would find the work as a whole appeals to prurient interest. So we get a couple things here. The community standards that are like nationwide standards, not just sort of like varying from person to person, and the work taken as a whole. So we know that a lot of times people will come to a board meeting at a school or for a public library, and they'll say, you know, this book is offensive because I don't like this chapter, I don't like this picture, I don't like this particular excerpt. That's not enough. The whole book has to be considered to lack serious literary, artistic, political, or scientific value. So harmful to minors. So in the Ginsburg case, they really applied the Miller test here when it comes down to it. It does parallel the obscenity test, but the considerations here are specifically in the context of offensiveness and serious value for minors. This is really important because it brings up the idea of keeping books around based off of your oldest minor. So you need to look at all of your books from that perspective. So just because someone deems a book to be maybe unsuitable for maybe a 5-year-old, especially in like a public library setting, your oldest minors in a public library are 17. So the book does have value for a 17-year-old, and it's not meant for 5-year-olds. So using that age as a reason to remove a book or segregate it into a different spot, according to Ginsburg, is not acceptable. Remember, in your school libraries, your oldest minors are going to be different based off of the age group that you work with, but still you don't have to make your purchasing decisions based off of your youngest students. It's always the oldest ones that are under your purview. And so for serious value, This again gives us the instruction to look at a material as a whole when we're considering it as harmful to minors. This again is decided based off of a reasonable person concluding that a book has some kind of scientific, artistic, etc. value, and therefore is going to be protected under the First Amendment. So we did want to touch a little bit on obscenity law exemptions. So most states have in place exemptions for museums and public libraries and academic institutions to have certain materials without being charged with obscenity. But we know that also since 2023, over 100 bills have been filed in 33 states trying to remove those obscenity exemptions. And that has happened in 6 states. However, even with that, and they're also trying to just skip that piece and just going straight to prosecuting librarians and, bringing in law enforcement and saying these people have committed these crimes, showing children obscene things. Even with those exemptions removed, if anyone wanted to try to bring criminal charges against a library or the library staff, they still have to prove under the Miller test that the material in question is obscene, which over and over again, we have seen that has not actually come into play. There have been several cases recently where someone has tried to file charges and the lawsuits have been dismissed or dropped because they look at the book, the judge goes through the Miller test, and the material's not meeting the criteria for obscenity. And so those charges are going away.
Um, so one of the books that has been challenged a lot is Genderqueer, which you all have probably seen. And this book was not found to be obscene after meeting after being looked at by various courts. So in Virginia, a court dismissed the case, and yet it still continues to be one of the most challenged books. But part of what we should note is how powerful a lot of these books that are being challenged are for the youth that we serve. Um, these books help people see themselves in the world. They help them to find their place and see a place for themselves. So our work is really to continue to protect and defend the value of writing for youth and for all of us. And in the slides, there's a link to the book resume for Genderqueer, and Unite Against Book Bans has put together a lot of really great resources that include book resumes that we'll share with you later. So we have a lot of precedent to base our work on. There are a lot of challenges right now, a lot of questions about where these precedents are going. But right now, we still stand firmly with the First Amendment rights to receive information and to express ourselves in public libraries. One of the major cases, Kerrie kind of touched on this earlier, was the Board of Education versus PICO. It was decided in 1982. It's an extremely important case, which was initiated by students after the Board of Education ignored its own policies and ordered the removal of books it found to be anti-Christian, anti-American, anti-Semitic, or just plain filthy. The court found that petitioners possessed significant discretion to determine the content of their school libraries, but that discretion may not be exercised in a narrowly partisan or political manner. So we're really looking at the issue of viewpoint discrimination, and the court said that local school boards may not remove books from school libraries simply because they dislike the ideas contained in these books and seek their removal to, quote, prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion. And they cited the Tinker case in their opinion as well. This case helps support the notion that there should be viewpoints of all kinds in libraries and that preferencing viewpoints is a violation of patrons' First Amendment rights. Um, so once once it's established that someone has the right to receive information, and we're referring to libraries as designated public forums, this is for public libraries specifically, that we have to really think through how we navigate the spaces of public libraries and how we write our policies. Because as public libraries are considered limited or designated public forums and are interpreted in jurisprudence as places where the public has a right to engage in free expression of ideas without restrictions, except for the rules and policies that apply to those spaces, like hours, meeting room policies, other kinds of policies. If your library has open meeting rooms, for instance, you must be open to all members of the public equally. Likewise, collections meet the need of the broad public in all of its variety of viewpoints. Unless a book meets the legal definition of obscene, harmful to minors, or child pornography, there is no compelling reason to remove it other than as defined by library policies that govern weeding or other collection development activities. So far, the courts have continued to hold firm on this point. Um, so policies are incredibly important. They are your friends. You may not be in the position to define your policies, but you might have the ability to influence how those, to ask questions, whether do we have a reconsideration policy that is up to date? Like, and that's one of the pieces that I think is really important to note, that thinking about where we are in 2025, you want to make sure that your policies are meeting this moment. A lot of us have policies that were maybe written in, you know, the 90s or the 2000s or whenever it was, and not having been revisited for a while. So check your policies in your libraries and ask your directors, ask your school boards, whoever your people are, how do we make sure that we have a way to meet this moment so that we are not um, having to do something that's just not well thought through as we meet a challenge or something. So always consult your legal counsel, your local laws. The American Library Association has a lot of great policies. There is an updated intellectual freedom handbook coming out soon. Um, and these are just some opportunities to think about ways that the policies in your libraries can be displayed, and also educate your staff about them. You can reach out to us. Obviously, we're here as resources, but you can reach out to people in your community, and the New England Intellectual Freedom Helpline, the Office of Intellectual Freedom at ALA, and your state intellectual freedom committees are all there to support you in making sure that your policies are in a good place should you have challenges of any kind. So there are a lot of cases before the courts right now that could change some of the jurisprudence that we've relied upon to protect our First Amendment rights. This case, Fayetteville Public Library versus Murray, is currently before the Eighth Circuit Court of Appeals. It The organization Fire filed an amicus brief in October of this year, and some of my notes are from that explainer. But this information in terms of the timeline, so they're filing briefs currently, but this law is really punitive and potentially offers jail time to librarians. So this is something we're closely watching. Arkansas's law compels public libraries to adopt policies allowing any person affected by a book to challenge its appropriateness, forcing libraries to remove or sequester the book in an area not accessible to minors if the challenge succeeds. The law provides no definitions for crucial terms like appropriateness or accessible, leaving librarians to guess how to comply and inviting challenges based on personal or political opinions. The process grants challengers the right to appeal decisions to keep a book in place while having no appeal procedure when a book is removed or segregated. The law undermines libraries' historic role as repositories of diverse ideas and viewpoints. By grouping all minors into one category and failing to define key terms, this law effectively criminalizes access to classic and educational works that may include mature themes. And one of the examples that they gave was Romeo and Juliet, that someone might find this sexually explicit or harmful to minors. And so it also touches on bookstores. And so it's a wide group of people that this law touches, and we are waiting to see where it's going. But so far the court has stopped it, but then the Attorney General in Arkansas intervened and bumped it to the Eighth Circuit. So we'll see where it goes. Similarly, Little versus Llano County in Texas, you probably have all heard about this case. It's a pretty major and potentially redefining case in terms of how it will be taken up or not by the Supreme Court. The original case involved 17 books removed from the public library after residents deemed them obscene or pornographic. As we noted earlier, pornographic and obscene cannot be defined by residents. It's only defined by courts. So this is immediately then like pushing it toward a legal situation. The books were returned to the shelves, and it went before the Fifth Circuit Court. It went to a small panel, and then there was a dissenting opinion that claimed that this was government speech. And in the past, library speech has not been called government speech. So this is an issue that we are really watching. The first the ruling in May reversed that decision and says that there's no First Amendment right to receive information in a public library. And kind of strikes down PICO as case law that holds precedent. So the American Library Association has filed briefs in this case and is really hoping that the United States Supreme Court will take it up. If it does, this will be a really defining moment for the future of First Amendment decisions regarding freedom of access to information in libraries.
All right, I do apologize. The children are moving through the hallways, so hopefully they won't yell too loudly because I am still at school. And just a note on Little versus Llano too, like the ALA seems very positive about if this goes before the Supreme Court. They seem to think that they'll actually stick with the PICO decision. So that's at least something that at least our large organization is, while this is very scary court rulings that just took place there, even though it only applies in the Fifth Circuit, it's still very alarming because people are using it now as like, well, look at what they did in the Fifth Circuit. But ALA's feels kind of good about where this could go if the Supreme Court takes it. So I'm going to take that as a win. All right, so Read Freely Alabama. They adopted two policies when a new board came on, and the lawsuit was filed because they said that the policies violate the First Amendment. So their selection criteria policy would prohibit the library from acquiring material advertised for children age 17 or younger that has sexual conduct, sexual intercourse, sexual orientation, gender identity, gender discordance. And they made provisions for things about biology and anatomy, but still. And that their library card for minors policy would not allow children 17 or younger from checking out materials containing those same topics. So this was filed in May 24, June 25. The library board made policy changes. So both parties were asked to determine if the complaints that they had amended were even necessary. July 25, the defendants asked the court to consider the Llano County case in its decisions. So again, Llano, people are trying to use it to their advantage. So we're still waiting to see how this will shake out. Book People versus Morath, which was Book People versus Wong. People were asked to not be part of the case anymore, so they had to change the title of this. But you may have heard of it through the title of Book People v. Wong. So again, this was Fifth Circuit, and this was based off of a piece of legislation, there goes my bell, that would really affect booksellers and their ability to sell books to school libraries. So this was known more informally as the Reader Act, and it would compel booksellers to rate every single book that they sell as either sexually explicit, sexually relevant, or none. So that was going to be completely on the booksellers to do that before they could sell books to the school libraries. And also that they wouldn't be allowed to sell books that were considered sexually explicit to public schools. In 23, the U.S. District Court barred enforcement of the law because they said that it violates the First Amendment rights of publishers and booksellers. And in October this year, so very recently, the same court found that the law was unconstitutional and granted a permanent injunction. This in particular, I had, there's my quote. I thought this was really important to read this directly, what the court said. They said that Reader fails to provide guidance on what community standard applies, and it fails to follow the definition of obscenity approved by the Supreme Court in the Miller test. And also that it's not merely the sale of books to public school purchasers that's being affected by Reader, it's compelling speech, which violates the First Amendment rights of the booksellers. So this, again, they relied on the Miller test, and this is where we're also seeing that idea of people trying to rate books. And while this does have to do with booksellers, there is some ways that we can apply this to our library institutions. Because part of this discussion was there's no real, the terms are vague. There's no real definition of what is sexually explicit, what is sexually relevant. And so the court did state that too, that like, this is it. We can't define this, so how would they be able to accurately label those books in that way? Mood versus Taylor. So this is also a more recent case that happened over the summer. So this may be another one that you've heard of, especially if you're in a school library. Parents sued their school district because they were not provided notice or the option of opting out of classroom story times when there were LGBTQIA inclusive books being read. The Supreme Court in June did rule in favor of the parents, saying that the lack of notice or the opportunity to opt out threatens the parents' religious beliefs. So there's been a lot of question about how this affects school libraries, because this was specifically about classrooms. And even the parents who brought forth this case said that they didn't have any issues with what was in the school library. This was more about the read alouds happening in the classroom that they couldn't opt out of. So Mahmood, and this is from ALA specifically, they provided this information very recently, which has been super helpful for school librarians. Mahmood does not give parents a right to veto any books being added to your school library collection. It doesn't let them pull books from the library collection. They can't restrict access to certain kind of books. It also doesn't create parental opt-outs for your materials in the school library just for checkout. It's also not requiring you as school librarians to create any content-specific opt-out policies that target certain topics or subjects. You don't have to create a policy that allows for opt-outs based on topic or subject. And you don't have to use any specific modes or processes to provide notices or opt-outs. ALA does suggest that, you know, it probably wouldn't hurt, like most schools and classrooms do, to have like a very basic, this is what we're going to be talking about in the library today, well, or through the year, sort of like a scope and sequence, but you don't have to list specific books or anything like that. It's still, I know it's still vague and that's not helpful, but there is a lot of protection here for school libraries right now, based off of the way that this case was submitted. It had to do more with classrooms than it does with the school library. And just a word about SEPA and internet filtering. So this is obviously what we have to follow to make it so that children aren't having access to harmful internet sources. Sometimes people will try to use this as a way to remove books from the libraries. It does not apply. If anyone tries to use SEPA to remove books from your libraries, they can't. It's not applicable at all. It only applies to the internet. That's all I have to say about SEPA.
So there are a lot of resources that are available to support you in your work as librarians. These are a few of the organizations. I saw somebody in the chat put a link from every library. They've really put out a lot of advocacy work in the last few years, and so they're a great organization to follow if you're looking to kind of see what's happening and get action items. Unite Against Book Bans is associated with ALA and has very similar kind of action items and things that you can do in your communities. Obviously, the Office for Intellectual Freedom is always a resource there for you. But newer and more specific to this area is the New England Intellectual Freedom Helpline, which was launched. We launched the site in May, and we are here to help support librarians in the New England region with pairing them up with librarians who have dealt with similar issues and most likely in your state, so that they're also familiar with state law and resources. And we work one-on-one with you confidentially to support you through a challenge of any kind. It doesn't have to be a book challenge. It could be something about policies or meeting rooms or displays or First Amendment audits, anything that you're facing that you need help and resources about, we are here to help you. So that link is how to reach us. Also, we are open to volunteers. So if you are somebody who's passionate about intellectual freedom and wants to help, you can find a link to sign up as a volunteer there as well. Do you want to share anything, Kerrie? I did mention your state intellectual freedom committees. So some states have joint school and public library associations, and other states have separate ones like Maine. So, but those are great places to get help.
Yeah, I don't have anything to add on that end. I don't know if we're ready to open it up to questions.
Yeah, I was just gonna go to our last slide.
Oh, right, that's
So
important too.
yes, we'd love it if you would fill out our survey. We were trained as Law for Librarians trainers by the American Library Association last year. Kerrie and I were part of the same group, and we've been doing trainings for the last year and a half. And we are required to ask you to fill this out. So if you would please do it, we would be very grateful. And also, it helps us learn how to be more helpful in terms of our presentations. So I'll leave that up for a bit. But yeah, I think we're ready for questions.
If you have questions, you can either put them in the chat and I'll read them out for Kerrie and Kathleen, or you want you can actually come off mute and ask your question as well.
Should I stop sharing at this point? That'd be better.
And I actually love to ask a question to kick it off. How is the helpline going? Have you started getting calls? Like, how is that process going for all of you?
Yeah, so the helpline is, I mean, going well in that we have gotten, I think we're at like 8 or 9 cases since we opened the training. We did 2 trainings for volunteers in October, and since then we have gotten about 8 cases. So we are up and running. We are staffed with volunteers. We are available to do presentations and to support libraries around the state. And as I said, we're always happy to have new volunteers. I'm not sure exactly when we'll be doing more trainings, but maybe once we reach a certain threshold of new people interested, we'll do another training. But it's been a great way to connect across New England. So all of the library associations from Vermont, Maine, Massachusetts, Rhode Island, New Hampshire, Connecticut have all been involved in the steering committee, and we're really excited to offer this way to get help more directly to librarians, because sometimes ALA's Office of Intellectual Freedom can get a little swamped and maybe not as easy to get a hold of. So we're hoping to help that process along.
Yeah, absolutely. And it's one of those
Thank you.
things that you actually want it to not be used a lot, right?
Yes.
But I'm so glad that you are all there and volunteers trained and able to help. That's great. Any questions from our audience? We've dropped a bunch of links into the chat over the course of the session, but like I said, they just asked if you could put the QR code up again.
I can do that.
Also, the slides are in the virtual tote bag, which I'll put the link in there in the chat again. And I'm actually
I will say, while we're waiting for some questions, one thing we didn't talk about, which I'll just mention very briefly, is litigation costs. I enjoy talking about that because sometimes that can really sway your board or the powers that be to take this seriously and know that maybe enacting a bad faith policy that's going to get them sued is not a great idea. The Lano case is already at $200,000 and is still going. So that's a lot of money that most municipalities or school districts just can't afford to spend. A case in Bergen County cost $100,000. There was an Alaskan case that they had to pay $89,000 to cover the plaintiff's counsel and plus their own lawyer fees. And it's exorbitant amounts of money. So just something fun to toss out there.
Absolutely. And great. There are a couple questions now. So in the chat, somebody asked, what is a book resume? They haven't come across that term before.
So that is, I don't, Kerrie, can you find the link to those? I'm like
I
challenged with all my
I can
screen
do that. I
sharing,
have
but
done that before.
Someone
okay.
did put it up, but I can put it up again.
So the book resumes were developed as a direct response to Moms for Liberty's website book looks, which provided these very negative perspectives on books and called out like very specific passages of that appeared to make the books seem obscene or not suitable for minors. And people were using these to go to school board meetings. So the some folks developed these book resumes. I think it's been a pretty widespread volunteer effort to pull together reviews and other information about the books that are frequently challenged so that you can easily go to those and say, okay, I need to speak about this book at a public meeting, and you have the information accessible to you there. You can find the reviews, you can find passages that will counter the very limited views that book looks provided and um, argue for the artistic quality of the materials. Is there anything you want to say, Kerrie?
No, I think you covered it.
Okay.
Unless somebody has further questions, we can try to dive deeper on about it.
And Kerrie, you already answered this in the chat, but I'm going to say it just since we are still recording. But there was a question about when you complete the survey, is there a specific state you want to select? And you said pick Maine. I
Yeah,
think,
let's
yes,
just choose Maine.
Yes, since the two of
Because
you are both from Maine.
yeah, we're the trainers from Maine, so I think that's, and then we
Perfect.
can sort of make it clear that it's New England, but
Yeah.
Any other questions? I'm going to stop recording. So there, if